Yo, what go on? Bless up. Big up on yourself, people. Welcome to another installment of the brand new music review show. Well, incidentally, we're not really talk about music, but we are talking about a court case that involve a very popular musician in the dancehall sphere, none other than Vybz Kartel. And this story has encapsulated the media for the last 5 days, and we still have one more day to go. Court proceedings closed Friday, which was the 5th day, day 5, and submissions and final statements will be done on Tuesday. I think that are June 18. Zane, but where I give you a review, an overview, a report of what took place, and of course, give my own interpretations of what took place and where we are in the case. Zane, before I go any further, I'm going to ask you please to like the video. You know me always ask, so I shouldn't even have to ask. You get to me, I say? So at some point in time, like the video. I'm not a fuck, hold on. So one time, yeah? You like the video? Yeah, man, give thanks. Because you know when we found a top shelf review, top shelf reasoning. Now, the first thing we make a comment on, Zane, is that on Monday, the judge had asked for an audit from the Supreme Court to see in the last 6 years how many cases have sent back to retrial and what is the progress and the status of those cases. She revealed to the court that she received the audit that from 2018, which would have been 6 years, there has been 2 cases, one in 2022 and one in 2023. And to date, there has not been a date set for the retrial. Zane, can remember she did want to know that because one of the lawyer them for Vybz Kartel team did I say, yeah, but even if there's a retrial, how long that I go be and will that be an extended time we go added to where we're there now? And you know, time is a very important factor so far because the man has spent 13 years already behind bars. So time is a very important factor in this. Don't forget that. And also we have to remember say couple of the man them up for appeal. Is it because of 15 years would that be not appeal, parole. You see me? So sorry about that. So it would have come up to the 15 years when they would have eligible for parole. So that is another factor with the judge that touch upon and I ask about how that I go do with the two of them being at that time. If there is a retrial/parole, how that part they go. So the judge had questions there. Now we'll get into the other factors and the other things that took place on day 5. So make we deal with it.
It wasn't the first time the prosecution was conceding that the men's right to a fair trial in a reasonable time would be breached by an order for a retrial. But this time, the team from the DPP's office acknowledged that the concession was a hurdle to the retrial order they were seeking from the Court of Appeal. Prosecutor Lorian.
So I'm going to pause to go into some context here. So couple of the keywords I'm going to pick up on is concede and hurdle. The reason why those words were used is that these people, the prosecution, are trying to get a retrial, to secure a retrial in the interest of justice for Clive Lizard Williams, who allegedly died. Zim, who them say kill, and you know Vybz Kartel accused that from 2011 and the 3 co-accused. Now the thing is though, because at the time, remember I'm just telling about the time we passed, there's something in the constitutional rights that says they must be given a fair trial in reasonable time. Remember, the entire process here go on. And as the judge pointed out, this thing is not just for count from when the Privy Council say, yeah man, conviction squash. No, you have to count it from when the men were detained. That is what the judge said. Not me, the judge will preside over the issue. So, a fair trial in a reasonable due time. You see that part, there are 2 conditions, fair and in due time and a reasonable time. You see the reasonable time, that is in big contention as well as the fair, because we are getting to that.
And Tugwell acknowledged the difficulty the prosecution faced soon after getting to her feet. Justice MacDonald Bishop commended Tugwell for her frank admission, pointing out that the prosecution needed to prove to the court that the acknowledged breach of the men's constitutional rights was justified under the Charter of Rights. The justice noted the prosecution would need to prove the justification with evidence.
So this is a critical and key point in other cases as it relates to the prosecution and what them need to prove. Them have to prove with evidence that it was justified. You see me? And the acting DPP in a day 4 did a list out all the things that were happening. I said, boy, because him did have the trial and then now the other one did take 21 months that a day court of appeal, and then now him did have a good, and the judge stopped her and said, listen out, the chronological order, the sequence of things is not giving justified evidence. Why? So right here, so we can say the judge asks a lot of questions that are not being properly answered.
Justice MacDonald Bishop pointed out that the clock started ticking on the men having a fair trial in a reasonable time after they were charged in 2011. She said it would be incorrect to believe the starting point was March 2024 when the Privy Council overturned their convictions.
All right. So right here, so we get to see where the judge depend. Right here, so we get to see. So the judge now look at this thing. Remember, the men were charged in 2011. When the convictions were quashed, is that the process start over again. So the men still have charges upon them because the convictions quashed, because they are considering a retrial now, which means the men are currently charged. That is why them thought the thing with the habeas corpus with the bail, because the men are charged. So bail would have come into consideration if people are charged. And because the bail never give the first time, it now give this time according to the new Bail Act. So there's several little things we are going on in that case here. But the key point is that this conversation is not one where just a start from the Privy Council gave their ruling. The conversation starts from 2011. As I tell you, time is a big factor.
In response, Prosecutor Tugwell noted that acquittal or dismissal of the case should be seen by the Court of Appeal as a last resort option. She said dismissing the case should only be an option in exceptional circumstances where a fair trial was completely out of the question.
Key conversation this, This right here, so the lawyer try to get in at the head of the judge. The lawyer just swing the burden from half of herself, which is the prosecution, and swing it back by the judge for say, really and truly still, the only way you guys should acquit this matter or dismiss this matter, is on exceptional terms, unless there is no absolute reason. I know I don't like the absolute reason. So that means 100%. There is no way that there will be a fair retrial. Zane? That's what she do, So she are getting at the mind of the judge now and say, I know whether we can prove if there should be a retrial, is if uno find in our mind, in our heart, that there is no possible way that these men can get a fair trial. That is the only way. But if uno have a 10%, if uno have a 15% thought in our mind that it is possible for a retrial for these men, then you have to do it. And in a way, them kind of concede this of say everything against them, Yeah, because it's like them a try bargain for a 15% or a 20% that there might be a free trial. Because them realize that there's about a 70% that there won't. But what them a try to do, I tell them, say, listen, the only way you fit give this thing as a dismissal or acquittal is if you know 100% sure. So if you not have 20%, if you not have 10%, if you not have, yes, because them know about that they chance, for them winning, So more than likely it's about 85 acquittal. But them I say, no give for 80. You not have no reasoning and listen what she has say. She has say, if you not have 85, that not good enough. If you not have 70, that not good enough. You not have 100. For make sure perfection are little below that. That's what she had try to say to the judge them. So the burden of upon we again for try for bring it up to 51% and above, which would be more than the 50%. The burden upon uno. You get what me I say? That I wish she had done. And she's saying that we have a percentage chance that we can grant a fair retrial. Very key reasoning this, because she had tried to sway the judge.
Out of the question. The prosecution maintains that a fair trial for Kartel and his co-accused was still a strong possibility if the case is sent back for a retrial. During the morning session of Friday's hearing, Prosecutor Jeanette Forbes told the three-judge panel that sufficient safeguards existed to manage any risks that pre-trial publicity may cause. Forbes urged the Court of Appeal to trust that an impaneled jury would take their oath seriously and not be unduly influenced. He says, despite the high publicity in the case, the judges should look at other high-profile matters in coming to their decision. Forbes highlighted the U.S. case of Bill Cosby and the South African case of Oscar Pistorius. Forbes said judges allowed those cases to proceed amid heightened publicity because of the interest of justice.
Now, I want to give some more reasoning upon this, some more context upon this, and expound upon this. Now, firstly, the prosecution had to find cases outside of its own jurisdiction, which is Jamaica. And it went to the Bill Cosby, the Oscar Pistorius case. The Oscar Pistorius case, the South African runner. Him did shoot him wife, I think, or him fiancé. I mean, if you remember that story there. And the other one was the Bill Cosby as it relates to the sexual things. Now, what the prosecution do is for sure that there are other cases that in the interest of justice, even though there was high publicity behind them, they were still considered and the judge still went on with them. Two things with that though, when you make comparisons like that, or when you try to get a precedence thing, is that the comparison of a closer. I'm going to tell you why I'm going to think the comparison closer. One, I could use the Bill Cosby. That's not a murder. The simplest one. That's simple. The Pistorius one was murder, but I could look at this. I tell you now already, time is a factor. In Bill Cosby case, he was not imprisoned for 13 years, and our Oscar Pistorius was not imprisoned for 13 years, and the information was being circulated widely on the internet in America and in South Africa before there was a trial. That wasn't the case. That was never the case. The information never take 13 years for simmer, 13 years to marinate in the minds of the populace before there was a trial. And we have to remember that that's what the judge will look on, the pre-trial publicity. So before the possible retrial, publicity. Also, we could look on even Bill Cosby. We have to look on certain context. Context matter. Bill Cosby, you try to get a 12-man jury, or 12 people jury. And you try to get that from 300 million people in America. The probability of getting 12 people from 3 million that are unbiased is greater than for get 12 from 3 million. The maths alone show you say 1 I got 100 times better odds. 100 times, because 3 million versus 300. By the way, 300 odd million people in America. So the point of me I say is, there is a possibility say you might get 12 people when no bias significantly enough against Bill Cosby or whatever. Yeah, they might know him, but it's not just the knowing the person, you know. That conversation would have been better suited if it was at the time when Kartel did just get locked up. When you just look on the publicity of the person. But you look on the essence and the evidence of the case being on the media and being in the public for over 13 years. Big difference.
Justice MacDonald Bishop appeared unconvinced by the comparisons, pointing out that each case had to be judged on its own merit.
All right, you see what I mean? You see what I mean? She seems unconvinced because Any logical thinking person would have made the comparison and say, nah man, are two different, they have a judge on two different scenarios, and two of the scenarios is the amount of publicity, and it is a sample size of the country. That is why the comparison was inadequate. It's like you compare apple and orange.
In closing the prosecution's case, Tugwell told the court that it was because prosecutors cared about Kartel and his co-accused why they wanted the case tried on its merit and not simply dismissed on a technicality. Final arguments in the case are set for Tuesday morning. It's unclear when the Court of Appeal will deliver its ruling.
Hey, me have to laugh, you know. Lies about psychology and about colorful language and how you present your points, you're convincing. Now, they must say this is in the interest of Vybz Kartel and his co-accused, clearing their name and not just seeing that they got off as a technicality. So, you do realize along the way of this that them actually sound like them are entertain the idea that the dismissal or the acquittal is very eminent. That's how them are sound. Now, that technicality which she mentioned is actually the inadequacy of the court of Jamaica and the Crown if you can investigate and fairly try Jamaicans. You hear? So that technicality there will rest squarely on your shoulders. Yeah. Because from day one, when the juror was tainted, this is where the error happened, on phone side. And when certain evidence were accepted, that this it happened from that time there. Anyway, I have nothing else to say now. I'm out. Because for yourself.